This is the American Law Journal.
Generic drugs, yes, they're cheaper than brand names, probably just as safe, but if one injures you, don't count on the courts to help you out. Good evening, I'm Christopher Naughton. Welcome to the American Law Journal. Do you have less legal protection if you're harmed by a generic drug versus a brand name drug? Some people are finding out the hard way. Gina Passarella with the Legal Intelligencer reports.
Generic drugs are king. About 80% of all prescriptions in America are now generics. But if you take one over a brand name drug, you could be playing without a safety net. Take the highly publicized case of Diana Levine, a musician who had her hand and forearm amputated because she was injected with an anti-nausea drug causing gangrene. She sued the drug maker, Wyeth Pharmaceuticals, for failure to warn about the risks of injecting the drug. Her case went to the U.S. Supreme Court, and she won $6.8 million. Compare that to Debbie Shork, a deli worker from Indiana who had her hand amputated after a nurse injected her with the same drug. Her case was thrown out. The difference? Ms. Levine had been given the brand name drug Phenergan. Ms. Shork received the generic version of the drug. So why the distinction between a brand name and a generic when they're really the same drug?
The Supreme Court in June of 2011 decided the Mensing case and said generic drug manufacturers don't have a duty to warn. They don't have to do anything more than what the brand companies did.
So it's had a tremendous impact on the product liability litigation against generic drug companies. And it really was sort of unforeseen. I think it was totally unexpected by the generic drug industry and certainly unexpected by plaintiffs' counsel.
In the 5-4 Mensing decision, the Supreme Court said the FDA makes generic manufacturers follow the exact same label warnings as the brand name drug. Since generics are not the authors of the label, they can't be held liable for a failure to warn. To Eisenberg, that confounds courts and consumers.
So in the law, there is some sort of disconnect that courts are struggling with, and they're having a difficult time saying to patients and lawyers, you're without a remedy.
But some courts are finding a remedy in California, Alabama, and in New Hampshire. That's where the story of Karen Bartlett started.
Generic drugs and brand name drugs should be equal.
Her fate now rests with the U.S. Supreme Court.
Yeah, the Bartlett case is an unusual decision. A woman took a drug, anti-inflammatory drug called Solandac, and suffered an extreme allergic reaction. Almost died. Tragic case. A jury awarded her $21 million on the theory of design defect.
Design defect. That's how consumers are winning, not a faulty label or failure to warn. But not so fast.
So I think the prospects of Bartlett standing are pretty slim at this point.
The U.S. Supreme Court expressed skepticism when it heard the Bartlett case argued before it this spring.
The jury decides all of this, huh?
That's correct, Justice.
That's wonderful.
Well, the FTC...
12 tried men and few and true decide for the whole state what the cost-benefit analysis is for a very novel drug that unquestionably has some deleterious effects, but also can save some lives.
Either way, this issue isn't going away. 4 generic drug cases have been addressed by the U.S. Supreme Court in less than 2 years. And on top of the injury matter, there are complex business and patent questions that still need to be answered. As courts grapple with how to tackle these legal questions, plaintiffs' lawyers are looking at how to get their clients relief. That inevitably means more litigation. The takeaway? Expect generic drug cases to have a home before the High Court for years to come. For the American Law Journal, I'm Gina Passarella.
All right, the health and legal risks of taking generics, not to mention the battle going on within the pharmaceutical industry. We'll cover that and more. 4 guests weigh in this evening. Let's go ahead and meet them. Claudine Homolash, plaintiff's attorney with Scheller PC. The firm is at the forefront of pharmaceutical product liability and whistleblower litigation. Dr. Paul Langevin is with us for the first time tonight, anesthesiologist with Hahnemann University Hospital in Philadelphia, also an associate professor at Drexel University College of Medicine. Terry Henry is a commercial litigator with Rome. He focuses on defending medical device and pharmaceutical companies. He represents several generic drug manufacturers. And Professor Kate Greenwood returns to the program, research fellow and lecturer for Seton Law's Center for Health and Pharmaceutical Law and Policy, and her research includes prescription drugs and generics. Let's take a quick look at this graphic. I think this at least explains where generics are today. We've had them in our stream of commerce in America since 1984. Generics now make up about 85% of the U.S. market. One study claims that the U.S. healthcare system is saving over $1 trillion in a 10-year period, and most of these generic drugs are about 80 to 90% lower than their brand name equivalents. Let's start with the health aspects first. Let's go to you, Doc. Do you believe that if I take a generic that I can willingly rely on the generic to be as safe and as effective as the original brand?
Well, certainly the FDA, when they approve a generic drug, assures us as physicians that we're dealing with a bioequivalent preparation.
So it really should be the same drug except for the name, more or less?
More or less.
Okay.
Obviously, there will be some differences in compounding. There'll be some differences in the way the drug is prepared, perhaps, and those kinds of concerns. There may be some differences in the additives to preserve the drug. But for the most part, the drug itself should be a bioequivalent preparation.
All right, so that's why sometimes I'll actually hear people say, you know, I took this brand name drug and then they gave me the generic and I'm having this bad reaction, I don't feel well. So again, not really the identical drug. The compound may look the same, or if I were to look at it in some sort of chemical schematic, it should really show up as being the same drug. But you said compounding, so maybe the way they put it together could affect a patient.
Well, that's correct. There are other products in the preparation that can affect patients, sometimes adversely.
Gotcha. And do you make any difference between recommending a generic or recommending a brand name? Does it come down to cost at the end of the day?
Typically, what I will do is provide a patient with a generic drug unless there's some indication that the patient will not tolerate that drug.
Gotcha. So generic drugs are everywhere, and they're especially in the courts. I think the Supreme Court has addressed, generics 3 times in the last 3 years? Let me make it as simple as I possibly can. Let's say I'm taking Wellbutrin, and all of a sudden the doctor suggests that I take bupropion. And now I've gone from the brand name, I've gone to the generic. So the doctor tells me that I'll probably not going to have any kind of adverse reaction, but I would have an adverse reaction in a court of law. I might have a cause of action against those who produce Wellbutrin, but I don't have the same cause of action if I suffer the same injury if I take this other drug. What's going on here?
Well, I disagree with you on that. It depends on what kind of cause of action that you want to bring. First of all, if you want to bring a failure to warn claim, in other words, that whatever the generic drug manufacturer was didn't provide your doctor with sufficient information about the drug, then you'd be right. Those claims are preempted. In other words, you can't bring that claim against the generic
manufacturer. So a problem with the label, let's say. In other words,
Correct.
if a generic basically has got a copy of the label, more or less, of the brand name drug, and so they bring that to market, I take this drug, bupropion, and I've read the label, it's the same, or it should be the same as Wellbutrin, I don't have a cause of action against that generic manufacturer for that, failure to warn.
Correct.
Gotcha.
But you still have a cause of action if the generic manufacturer didn't manufacture it correctly.
So if I listen to Terry, it sounds like I have some daylight here, Claudine. If I get hurt by a generic drug, not much of a problem unless there's a label issue.
Most injury claims are based on a failure to warn theory. You have people who suffer adverse reactions when they take drugs. And a lot of times when drugs are manufactured by the brand company, afterwards, years and years later, it takes a long time to come to light whether or not there's a problem with that drug. Now that drug may be generic at that time. Now a consumer whose doctor just writes a prescription for a generic drug, goes to the pharmacy, fills the script, is given a generic. Sometimes the pharmacy will switch that out without even the patient knowing. The patient ingests the drug. Next thing you know, they have a problem and they have no recourse. It could impose some liability on the physicians. What are the physicians to do in this instance?
And yet, Doc, so far, doctors seem to duck most of the legal liability issues when it comes to brand name drugs. I would have to think you've got even a lower profile when it comes to generics.
Well, understand, a physician is responsible for the prescription that he writes. There's a certain number of patients who are going to respond adversely or have an adverse event from any given drug at any given dose. If the drug's taken incorrectly, if the prescription is written incorrectly, then certainly the physician is going to go ahead and be held accountable for his actions. However, When we write a prescription for a drug, we expect that the drug is going to be prepared and behave the way that the drug is supposed to be prepared and behave. That's what the FDA tells us they're going to provide us assurance for, is that all the drugs that we write, regardless of whether it's a generic or a brand name, is going to be bioequivalent.
And so, Kate Greenwood, if we go, let's go back 2 years ago. Supreme Court comes down with this case called Pliva versus Mensing. And all of a sudden, and again, one of those infamous 5-4 decisions, they basically say that when it comes to failure to warn, a generic manufacturer is off the hook. So if I have this right, brand name manufacturer could be liable, maybe for millions of dollars. Generic manufacturer, not liable. Are generic manufacturers getting a free pass here?
Well, yes, they do get a free pass to a certain extent, but generic manufacturers do not have the ability to make changes to their label. They have a duty, what the Supreme Court in the Mensing case called a duty of sameness. Their label has to be the same as the brand name drugs label.
Well, you have to understand, Kate, that although what you're saying seems to make perfect legal sense, if I'm a layperson and I've taken a generic drug and now my skin literally is falling off my body and I have a state that says that awards me $21 million for my injuries, most consumers are going to say, but I don't understand what the difference is here. If my quote unquote skin falls off with a brand name, I've got a cause of action. If it's a generic, I don't.
The generic manufacturer doesn't have that ability under the FDA's regulations. It can, in fact, the language of the regulation is that it should bring new safety information to the attention of the FDA, but it cannot change the label. The Supreme Court has held, and the FDA has provided that the generic label has to be the same as the brand name label, and that makes sense because the FDA is very concerned about a plethora of labels, all of which are different, and puts a high value on uniformity in service of safety.
So Claudine, that sounds eminently fair, doesn't it?
It reminds me of the game of Monopoly. This is a get-out-of-jail-free card for generic manufacturers. Generic manufacturers make up 85% of the market. They bring in over $285 billion a year on their drugs, yet they have no liability here, according to the Supreme Court. The Supreme Court got this wrong. I suggest to you that. The generic manufacturers are under an obligation to report adverse events to the FDA, and they have a duty.
Well, Kate agrees with you there.
And they had a duty to bring to the FDA the adverse events and suggest to the FDA, hey, the warning should be changed, and that.
Because a brand name manufacturer has that duty, do they not? If they find out that there's something not right about this drug, and the FDA has approved it and they've given it their blessing, but then the drug company finds out there's a problem with this drug, even if the FDA doesn't know, don't they have an affirmative duty to let the public know, to let the FDA know?
The brand name does, right.
Well, here's the problem. So the majority opinion also said, and for the purpose of deciding Mensing, assumed that the generics had a duty to let the FDA know when they thought there was a problem with the drug or with the label. But the majority also said that, look, these state law duties to warn aren't you have a duty to tell the FDA something's wrong. The duty is you have to change your label. And so what the majority said was, look, since generics don't have the ability to change the label under the regulatory scheme, they can't be held liable for a bad label.
They invented impossibility preemption in Mensing. And that's just it.
They being the Supreme Court of the United States.
The Supreme Court of the United States. We need a law put in place to change this. This does not protect consumers. This is wrong. When consumers rely on their doctors to write prescriptions that they think are the same, the bioequivalent, as the doctor has said, to the brand name drug, and now these consumers have no recourse, it's just not fair.
And maybe that's why we're starting to see some blowback in some courts of law, Terry, because despite the fact that the Supreme Court basically said, hey, if there's a problem with the label, don't blame the generic manufacturer. They're just mimicking what the brand name manufacturer did. Don't come after them. Your lawsuit is preempted against this particular company. But we're starting to see in some courts where they're starting to etch out some exceptions where they're saying, well, there might still be a cause of action. California's got several. I think Tennessee's got one. There are a couple of, and some of them deal with a Reglan generic, and it seems like it's catching on in 5, 6, 7 different jurisdictions across the country.
Well, that's correct. And I think, to credit the plaintiffs' bar, they've been very creative in trying to come up with arguments around the Mensing preemption. One of those is the case that's currently in front of the Supreme Court, which is the Bartlett case, was argued a couple of weeks ago. And in that case, the argument is that since the generics couldn't change the label, they should have just taken it off the market.
But the plaintiff in that case is not winning on a failure to warn theory, right? It's a design defect, correct?
Correct.
All right. So tell the public, what does that mean, and how does that differ from failure to warn? I'm sure Terry's going to tell you that they shouldn't prevail even with a design defect. They should enjoy complete preemption. Tell me why they did.
Right. Terry's going to say that really it's a failure to warn claim masked as a design defect claim, I would imagine.
We'll find out in just a moment,
right.
But go ahead.
But in that instance, the design is defective of the drug, and it's essentially a bad drug, and it should be off the market, and that's the argument.
Yeah, but here's the thing. I'm the generic manufacturer. Did I design the drug? I just copied somebody.
You did copy it.
Right. So why am I to help me out here, Terry, why am I liable if all I've done is I mimicked the label? Give me a pass. Now I've mimicked the science.
It's not an
Give me a
exact
pass.
copy, though.
Well, here's the problem with the design defect theory, and that is, so under product liability law in almost every state, the reason why you don't have strict liability in pharmaceutical cases is because these drugs come with known there's problems. People are going to get hurt taking these drugs. So you can produce the drug so long as you have the right warning. That's why there's no strict liability, no design defect claims. All right, so that's why these claims are failure to warn claims masquerading as a design defect claim. And what you end up having is, on the one hand, you have the FDA acting as the expert saying that these drugs are safe and effective. And on the other hand, where you have horrific harm to some plaintiff who is deserving of our sympathy, it's a one-off case. So you have 12 people deciding whether this drug is defective based on that one case as opposed to the entire scope of treatable injuries with this case.
Dr. Langevin, does this give you pause sometimes when you do prescribe a generic drug?
I do worry about that every day. And when I prescribe a drug for a patient, I do worry, regardless of whether it's a generic or a brand name drug, really doesn't make any difference. I worry about whether or not the patient is going to suffer an ill effect from the drug. And I know that can happen. And one of the things that we do to try to protect patients in that regard is to give them some understanding of what the side effects are of the drug that they should be that they're taking, and what to watch for. To call us and contact us if there's a problem that we can anticipate they might have as a result of taking the drug.
Right, but those side effects that you're anticipating for your patient are really based on the studies done on the brand name, the original, the root drug, if you will.
Well, that's exactly correct. And when the FDA says that this is a bioequivalent preparation, we expect that there's going to be consistency between the brand name drug and the generic drug. If that consistency is not present, then we don't have any way of knowing that unless the generic drug manufacturer has complied with FDA regulation and made the FDA aware that there's an adverse event or effect associated with their specific drug.
And you as a doctor, you don't only wish to have that information, you expect it, don't you?
That's correct, I do.
Right. But maybe the way the rules are the way the rules written right now is that the doc may not get that kind of information?
Well, understand, I don't get that information unless someone provides the information to me. Now, that can come
if there's a negative effect, you mean? In other words, if a generic drug is having a problem out there, but who's going to provide it to you? It's usually the pharmaceutical company, or you read it, peer review?
Actually, well, it may be in the peer review literature, but by that time, there's going to be a lot of patients who have suffered.
Yes.
So what we anticipate is that those adverse events are going to be reported directly back to the FDA, and the FDA is going to send us an alert.
Right. Claudine, you were going to say.
It also depends what state you live in. I mean, some of the states have ruled that a Dear Doctor letter is okay by the generic company.
Tell our folks what a Dear Doctor letter is.
A Dear Doctor letter is, or a Dear Healthcare Provider letter, is a letter that the drug company puts out to notify physicians when something's wrong with the drug or there's been adverse events. So the doctor who prescribes many drugs daily gets this letter and knows, hey, I should be on the lookout for this, or maybe I won't prescribe this drug in certain patients. And those letters are really important in the healthcare industry.
Well, provided that the generic is manufactured correctly and it is the bioequivalent of the branded drug, then whatever adverse events the generic manufacturers are experiencing, it's going to be experienced on the branded side too. So, and that's information that is generally out there for the medical community to see.
In the metoclopramide litigation, that really wasn't the case. I mean, the adverse events came out, or the reports of adverse events came out long after the drug went generic. And that's one of the issues now. And sometimes you have a drug that's more widely prescribed as years go on, and then you see more adverse events, or you have other companies doing different studies, comparison studies, and then the adverse events are more evident. And it may be after the drug's generic.
Well, that's where the issue of significant scientific evidence is presented to the FDA in order to get the advanced, better warnings incorporated.
There's this great, interesting case which you folks have been alluding to, we've all been alluding to tonight, that's come out of all places, Alabama. Alabama Supreme Court, and it's a Wyeth v. Weeks, and it's about someone taking the generic form of Reglan, metoclopramide. Did I get it? Okay. So that's what he or she is taking, the plaintiff was taking in this case. Didn't the judge more or less say, and I'm synopsizing here, look, someone's been injured. Somebody better take responsibility. Who's going to raise their hand and take responsibility? Is it the brand name manufacturer or the generic manufacturer? Now that's Judge Naughton condensing it, but is there some accuracy to what I just said?
Well, it seems like someone needs to be responsible, so in that instance, it was the brand name.
Okay, and that's what is real. This is a big sea change for you too, Terry, because now the gun's being pointed back at the original brand name manufacturer, which has got to please big pharma clients.
Actually, the big pharma clients are pretty upset about it because they're being held liable for a product they never manufactured, and that is it never happens in product liability law. In fact, if you look at asbestos litigation, where everybody and their brother gets named as a defendant in those cases, they have this doctrine called bare metal doctrine, where if you provided this valve with an asbestos gasket, but years later it gets replaced, you're not going to be held liable for the asbestos that you knew was going to be used with your product. And so, in asbestos litigation even, they've said you can't be held liable if you didn't make the product. But in this Weeks case that you mentioned, this Alabama Supreme Court said, we don't really care, brand and manufacturer, if you didn't make it, we're going to hold you liable, which is, it's kind of crazy. As much as you hate Mensing, we hate Weeks. So it's equal.
Kate, you used to work with the FDA, or actually the pharmaceutical companies. What do you think about this Weeks case out of Alabama? Intriguing, no?
Well, I think that the legal theory might well be sound, actually. The claims at issue don't relate to manufacturing or the manufacturing process, which the Alabama Supreme Court relied on in part in coming to its decision. The claims relate to actions taken by the branded manufacturers who are the defendants. These are the branded manufacturers it was their agents who were in the doctor's offices, it was their pharmaceutical sales representatives who allegedly hid safety problems with the drug at issue, who put a positive spin on the branded drug. The physicians relied on that positive spin in prescribing the branded drug, and then when it went off patent, in prescribing its generic follow-on. And so the claims relate directly to that alleged fraud perpetrated by the branded manufacturer. So to me, it makes sense that it would be the branded manufacturer held liable because...
Well, I'm not betting man, Kate, but I'm thinking if this case gets up to the Supreme Court, and much like I think in the Bartlett case is not looking good for consumers, I just don't see this U.S. Supreme Court buying that theory. You don't, Terry, right?
I don't. Now, I'll tell you, the Alabama Supreme Court was very clever in how they separated this claim, which was originally a product liability claim, into some kind of misrepresentation and fraud claim. So you kind of get out of that area of, well, they have to have manufactured the product to be liable. So in that respect, I have to say that the court was clever, but it wasn't fooling anybody. Everybody knew that it was, trying to hold somebody's feet to the fire. And it was very clear also from that opinion that the court did it in response to Mensing. I mean, if you read that opinion, it's all the court was saying, well, before Mensing the law was this, but now after Mensing, we're going to say this. So
Doc, let's get some last words from you before we have to part company this evening. Where do you see this going and impacting your profession?
Well, certainly we as physicians have to know that the drugs that we prescribe are what the drugs are purported to be. We rely on the FDA to make sure that the drugs are tested adequately and that they have an understanding of the side effects, that those clinical trials, phase 1, phase 2, phase 3 that were done were carefully scrutinized and that we know what we are prescribing. And then for the generics, when they come online after patent expiration, we need to know that not only are they therapeutically equivalent, but if there's a different set of side effects associated with the drug, that we know that too.
You better, right?
If at any point in time that breaks down and we don't have that information, then we're likely to be injuring patients inadvertently, but we're still likely to injure a patient.
Right, flying blind. And Kate Greenwood, from your perspective, where are we going next?
I think it's extremely important to balance, on the one hand, our desire for innovation, on the other, the need for patient safety. I think that generics, as important as they are only going to become more important as we see the rise of accountable care organizations and doctors are incentivized to keep down costs. We need regulatory changes that would increase the responsibilities of generic manufacturers to play a role in the post-approval pharmacovigilance effort should be made.
Terry, I have to think if I was standing in your shoes, I'd be feeling pretty confident right now. Most of the decisions have fallen on your side of the ledger, and even though there are a couple of brush fires here or there, and again, arguendo, given the makeup of this Supreme Court, I'd feel pretty confident if I were in your shoes.
Well, I think we on the defense side and certainly my clients feel confident in where the Supreme Court's going to roll on Bartlett, but that doesn't mean that they're sitting back and thinking they have a free pass. I mean, in the few gaps where plaintiffs have made progress, such as failure to timely update the warnings as opposed to, failure to warn, they have gained some ground. And so I know my clients are being more vigilant about when there's a change in the label, to be right on top of it, to be making the change that they need to make, and to get it out into the field. And as well as pharmacovigilance, as Kate had said, I mean, they're staying up to speed on that too. So.
And Claudine, plaintiffs are starting to show some victories in some sectors, and even though I think that this current Supreme Court would probably overturn those positive or beneficial settlements that plaintiffs are enjoying right now, you might just be one Supreme Court justice away from getting the kind of consumer protection that you're talking about.
I hope it changes. I find it appalling that the generic drug companies are saying our hands are tied, we can't change the label, we can't do anything, but at the expense of patients who are mostly prescribed generics and physicians who don't know what's going on with the drug and what the problems are. It's a disgrace.
I want to thank Claudine Homolash from Scheller PC, who's represented claimants throughout the country on matters dealing with pharmaceutical product liability and whistleblower litigation. Dr. Paul Langevin, anesthesiologist with Hahnemann University Hospital and also an associate professor at Drexel University College of Medicine. Terry Henry joined us tonight, again from Blank Rome, commercial litigator with Blank Rome, focusing on defending medical device and pharmaceutical companies. And Kate Greenwood joining us again from Seton Hall Law's Center for Health and Pharmaceutical Law and Policy. Kate, thanks for joining us this week. And for all of us here at the American Law Journal, thanks for joining us this Monday night. And until next week, case closed.
Tonight's American Law Journal has been made possible in part by Blank Rome, a national multi-practice firm with more than 400 attorneys in 10 offices. Blank Rome's highly regarded employment law practice has provided strategic workplace advice to employers for over 60 years. Scheller PC, a nationally recognized personal injury law firm protecting individuals against dangerous pharmaceutical medicine, including antidepressants, antipsychotic drugs, defective products and medical devices, and other personal injury matters. And the Legal Intelligencer, the nation's oldest legal newspaper for lawyers.